Pierre, thank you very much, Deb, and thank you for the organizers. So I think, yes, I can sit here and grab as much as I can from my 20 minutes and talk about something very European. And the reason why I will do that is that since I started teaching here, I realized that people um, get very surprised when I say that digital platforms in Europe are pretty much regulated. So they think that regulation of digital platforms is mainly the GDPR, and then when they realize how much regulation dwells around digital platforms, they get very, very, very surprised and sometimes even disappointed. So what is it all about? The title is a little bit slightly different from what Deb has told you. Maybe I would sit here so that you would see better. Okay. No, no, I'm fine. Thank you. Okay. So, okay. PSD2 is the European Second Payment Directive, which entered into force in January 2018, which was aimed to actually establish a pan-European and opening up markets for digital transaction and digital payment. And basically, it is also known as open banking, which may sound to many as an oxymoron. Well, from a closed and old system, we should be moving toward an open one, where a plethora of online services, such as robo-advice, consolidated account, and information services or payment services are offered in a myriad of digital operators, all in a shadow of blue, as you can see, known as fintech. But how would that be realized? Basically, according to what is known as access to account rule, banks must provide data, especially customers' account data, with their consent to third-party providers, which are also called PISP or AISPs, which are Payment Initiation Service Provider or Account Information Service Providers, free of charge and outside any contractual relationship with the bank, using a system that is based on API. Of course, as we all know, liberty may require some heavy means, hard means to achieve. And sometimes regulation may serve a function of opening up markets. Well, I mean ex ante, hard regulation. Now, the question is, why? Why was the ex ante regulation adopted in the first place? Well, the first answer is that it was needed to promote innovation in fintech. The second answer that is commonly given is that it was needed to protect consumer safety and improve customer experience with new payment system and fintech. And the third one is that it was needed to promote competition by ensuring a competitive level playing field. So, and now I want to see whether these three rationales are really true. So how was it how was it done? Firstly, first rationale, to foster innovation. Well, was it really so? In my view, it is not really so. actually e-payment, e-wallet services were sparring despite the XSA rule. Let's think about PayPal, for instance. Second, fintech tend to innovate disruptively. That means that fintech usually use spaces that are left free by regulation. So they tend to hate regulation. They spar where regulation does not exist. And these services were not regulated or were very slightly or lightly regulated. Then another reason, another rationale, is that the rule was introduced to let third-party service providers accessing data that they would not have access to for privacy reasons. Well, also in this case, I would say not really. And the reason is that the GDPR actually entrusts private consumers with the right to data portability. And therefore, even in this case, private customers would quite easily ask their banks to transfer the data to fintechs. So even under this angle, the access to a rule would not seem justified. A third and much more stronger argument would seem to be the third rationale, lack of competition. So the rule would be justified because incumbent banks are reluctant to release account data that are essential to promote competition among fintech and the traditional banks. Well, however, even under this angle, I would say not really. And the reason is that if we consider data, and especially personal data such as the customer account data, as databases, there is already the database directive which allows a sui generis right to access databases for commercial purposes. There is no doubt that access by a fintech is an access for commercial purposes. So what is the difference? It is that a sui generis right under the database directive would be paid, and also that there would be a contract to pay. So it would not be for free, as in the access to account rule. So what is the rationale then? There is no clear justification for such a rule. Or better said, the goal seems to be one, to increase the circulation of data from the banks, the traditional banks, and the fintech, and to make it easy and economic. So that leads us to the core of the paper, which is who are the fintech firms that are seeking access to account data? Okay, they can be either fintech startups, just let's think of Money Farm or Satispay, which tend to be highly innovative and that may lack data infrastructure to start operate. But they can also be the big tech or digital conglomerates. In this case, they may need information on accounts that may add to other behavioral data, which are highly profiled and granular. So what is the problem there? Is that the PSD2 directive actually allows all fintechs, so both startups and the big techs, to use, store, and access those data, account data, and therefore to run analytics on those data, provided that eventually those data are used to further ameliorate payment services. In other words, they are allowed to merge those data, those financial data, accounting data, with other data at their disposal. So the question arises, is the access to account data well suited for both fintech startups and the big tech? And especially, is proportionality met? Why do I bother with proportionality? Because proportionality, together with the neutrality, technological neutrality, are the two main principles governing regulation in the fintech realm. So we absolutely need to consider these two principles when designing regulation in this realm. So what is the main difference between the big tech and the fintech, which are not the big tech, and the banks? It's that the big tech can run a lot of analytics over the data they retrieve from the banks, which are real time, and which tell different stories from the data they can gather from selling past resales, like for instance data that Amazon can have. While fintech will only, in general, disintermediate one single phase of a chain, of an industry chain, not necessarily the whole chain. What about the bank? The bank do possess a lot of data, but not necessarily of the whole life experience of consumers, while the big tech tend to be very consumer-centric. So, what about proportionality? The main question is whether the proportionality principle is met or not. Because the proportionality principle says that whenever you design regulation in the fintech arena, you need to look whether the addresses of regulation look similar in terms of dimension, size, or typology of addressee. So the proposal. The proposal is that the access to account rule be revised, or better, be amended in order for a reciprocity clause be added to it anytime access is sought by a big tech. What does it mean? It means that anytime, I'm sorry, oops, okay. It means that anytime access to account is requested by one of these tech conglomerates, then it should be allowed under reciprocity. Why that? Because there is now a big debate over the big tech disrupting the banking, and especially the risk of marginalizing banks and the risk of a loss of consumer welfare because of that marginalization of banks. Especially because the banks are now, traditional banks are now, have less analytics consumers and have only very specific data which relates only to the financial life of consumers. Allowing reciprocity would increase the capability and the availability of data to the banks, to the traditional banks. And also, it will increase their ability to merge different kinds of data. So how would that reciprocity work? First, the reciprocity would make the access to account remunerated, which is now the most important problem for the incumbent banks when they receive the request of data from any fintech. And it will make the access request remunerated according to the pay by data scheme, which is very easy to implement, provided that banks would access the same customers' behavioral data as defined by their explicit consent. What do I mean? Once access to accounts is requested by a big tech, then a reciprocity clause would apply. And that clause would imply that about the same customers, data from the big tech and pertaining to the preference, habits, conduct, coming from the research, social network, comparison tools, pertaining to the same customers will flow from the big tech onto the banks, under condition that the data will only be used to enhance the payment services. In other words, those data will not be used for other purposes, but inasmuch as the big tech would access the financial data only for the purpose, under the condition that those data will be used to ameliorate the payment service, the same condition will be applied also to the how many minutes? 3 minutes left. That's perfect. Of course, in order to avoid that there will be other, that the a fintech startup will scale up to become a big tech or will be acquired by a big tech, small fintech will be exempted for reciprocity, but once they will scale up or will be acquired by a big tech, then the reciprocity will apply again. What for? The main reason to apply reciprocity, as I told already, is to make the online payment industry grow even faster than it is now, but also to better serve, to provide better services for consumers at lower prices, because that will increase competition on the supply side. And it would also reproportionate the access to account rule. Anytime its application provides its beneficiary a disproportionate competitive advantage. This is a proposed formulation which you will find on the paper. And despite the pros, which I have more or less already provided for, there are, of course, also some cons which may be seen in the lost opacity for consumers. It will be, of course, easier to detect the black sheep. So we have banks, traditional banks, we are all very happy that they are not efficient, that do not have so many data about us. With the reciprocity clause, they will have too much data, and they will become probably too efficient and detect the black sheep much more easy than now. Yes, I know, of course, but we have to see this proposal in the long run, and in the long run we will go towards a future of artificial intelligence, and in a future of artificial intelligence, empowering consumers means, at least to me, meeting the challenges of integrating law with the operating capacity of algorithms. So we have seen today a lot of proposals. To me, it means trying to integrating these two, and that's what I'm trying to do here at the Hebrew University, where I'm conducting my visitorship. And upon these notes, I just thank you so much.
Thank you so much for the introduction, and thank you all for sticking around with us. It's a pleasure to be here, and I hope in the next 20 minutes I will give you a quick outlook over the problems that personalized pricing strategies bring along and how the law should deal with that. While I focus on German and European law, most of the results will be directly applicable to other jurisdictions as well, as long as they are based on a free market system. In the following 20 minutes, I will talk about what are personalized prices, so give you a basic definition that I work with, the current implementation and the future outlook, the risks and chances that come along with such strategies, and the legal situation at the moment and what further regulation might be necessary. As we are lawyers, the first and most important question would be, what do I understand under the concept of personalized prices? Maybe some of you have a vague idea, but let's dig into it a little bit so we have a common ground. When setting a price for a product or service, business is always struggling to find the most efficient price. If the price is too high, the profit margin increases, but demand drops. If the price is too low, demand increases, but the profit margin shrinks. In the latter scenario, those consumers that would have bought the product in any case would profit, as they would have to pay a lower price. Their so-called consumer surplus would therefore increase. When introducing personalized prices, however, the economic incentive is the hope that charging every consumer according to his or her willingness to pay, this consumer surplus could be absorbed while increasing the number of sales and profit margins. That was a little bit abstract, so let's have a look at an easy example to figure out what this mechanism means. Imagine a photographer selling copies of her work in her gallery. After proper research, she figured out that the people are willing to pay between 50 and 200, let's use shekel here, it doesn't really matter. So she decides to set the price to 150 shekel. If we now imagine 4 customers, each paying 50, 100, 150 and 200 shekel, or willing to pay that amount, the gallerists would only be able to sell 2 copies and make a total revenue of 300 shekel. Now if she would change to a personalized pricing system, she would actually be able to sell copies to all 4 customers and make a total revenue of 500, increasing demand and revenue. As we have seen, the dependency on the willingness to pay is the key distinction for personalized prices. In order to carve out the cases that are truly relevant for legal analysis, there are some further elements necessary to properly demarcate personalized pricing from other pricing strategies. Bundling those elements together, we come to the conclusion that I have in my dissertation, that a personalized price is a price that is set by one side, automatically and on a single case basis, based on the esteemed willingness to pay of an assumed legal subject. This definition allows us to demarcate or delineate from other relevant pricing strategies you could think of. Fixed prices, obviously, dynamic prices as we know them from the gas station or flight tickets, negotiated prices, and other forms of price discrimination as nonlinear price fixing or market segmentation. And finally, it leaves out less relevant cases, as we have, for example, on the local market. So after we talked about what personalized prices are, the important question is, do they exist or will they exist? It's a little bit complicated, but the short answer is not really. They don't exist yet. This part is not really. While there have been various attempts around the world to implement personalized pricing, most notably by Amazon in the 2000s, but also in Germany, for example, by a supermarket chain called Kaiser's in 2014. So far, no broad application of personalized prices can be observed. Various studies have tried to identify the usage of such techniques through differing methods, for example, real-life users that shopped or fake profiles. One such study was presented by the European Union's Commission a little bit over a year ago, and they compared 34,000 product pairs in over 8 member states. For this field study, they limited their scope to the 4 categories that they thought the most prone to personalized pricing. That was shoes, TVs, hotels, and plane tickets. But even within those fields where you would expect the most results, only 6% of the observed products they found were personalized, had personalized prices, and even then the average deviation was only 1.6% from the standard price. So why is it that, considered the promise of increased revenue we've seen above, so little business owner actually implement personalized prices? There are different factors that are relevant, but the most important factors for now I would see as the technological hurdles and the fear of a consumer backlash. In order to work with individualized prices and the individual's willingness to pay, you not only need at least a basic level of information about this individual, but also the infrastructure to process that information and make use of it in personalized pricing. However, such technological problems become smaller and smaller each year, and at least for giants as Amazon or for Google, I think they will not really hinder the use of personalized prices anymore. However, they did in the past. On the other hand, the problem of consumer backlash is still highly relevant. Studies have shown that there is a big aversion of consumers against personalized prices, even in cases where the deviation is in their favor, actually. It just feels unfair to know that your neighbor pays less for the same product just based on the personal behavior or on differing personal profiles. So while we have gotten used to dynamic prices by now, which were as feared in the beginning, the thought of individualized prices still makes us uneasy. This was also the prime reason why the before mentioned examples of Amazon and Kaisers were seized and have failed, because both of them seized to bad press coverage. Amazon even went so far as to compensate their customers. But as so often with consumer experience, it's not only about the business practice itself, but also about marketing, dark patterns, and other marketing techniques. For example, the concept of personalized coupons instead of personalized pricing is way more appealing to customers, and prima facie seems fairer in comparison to the concept of personalized pricing, even though they have the same net effect. So in my opinion, I think once the marketing gurus will have the right framing for it, and there will be enough obfuscation for people to not realize that they are prone to personalized pricing, they will become a bigger thing. So the key question with this forecast is, what would that mean for our society? Do we have to fear such a development, or should we embrace it? To answer this question is the key of my doctoral thesis, but very, very complex. So in this talk, I will only be able to give you an overview of the most important effects I found out so far. And as personalized prices are an inherently economical topic, we will focus on the economical effects for now. As mentioned, the core idea is profit maximization through absorption of consumer surplus and increased demand. The scope handled in academia for these effects is for the revenue increase. They expect a change of or uprise of 10 to 20%. And although some of the revenue increase can be pinned to the increased demand, a shift of surplus from the consumers to the companies is inherent in the concept. Here, experts estimate a cutback of consumer surplus of roughly 25 to 33%. However, there's also a positive side to this, especially to the increased demand, because as the market might become more inclusive. In our example shown above, the customer willing to pay, for example, only 50 shekel for the photograph was only able to participate in the market and obtain a copy in the personalized pricing scenario. Another relevant aspect is transparency and information. As most here will know, prices are important from a market perspective, as they transfer information about the market, the good, and other relevant factors to both sides of the transaction, as well as controllers and judges. By changing to personalized prices, this characteristic of prices as information carriers is widely lost. Price comparison websites, for example, would not work anymore. Instead, a new aspect, instead a new aspect of information asymmetry would be introduced, rendering it hard for consumers to evaluate the fairness of a price. Equally, it would also become harder for new business owners to enter the market and set a proportionate entrance price, as it would be more difficult to evaluate the existing market. Another risk that I already shown that could go along with personalized pricing is the risk of manipulation. Personalized prices could be used to tamper with the consumer's preference in a very direct but subtle way. If a price-sensitive consumer normally buys a no-brand product, a limited time discount on the brand name product could be used in order to steer him or her into the habit of buying a higher priced product. The final thing I want to mention at this point is the inherent risk of the exploitation of dependencies. The willingness to pay is mainly influenced by the dependency on the product. When I have no viable alternatives and I need the product, I'm definitely willing to pay a high price. Ergo, linking the actual price to the individual's willingness to pay makes the price based on dependency. This per se is not bad. It is a core idea of supply and demand to link the price to dependency, and only in extreme situations the law has to weigh in. However, there's a difference whether I broadly and generalizingly build up on the dependency of whole market as such, or whether I price on the dependency of one single individual in a specific situation. If that happens on a broad scale, it calls for the legislator to have a watchful eye on it. The aspects we have looked into so far can be described as the direct effects, some of them intended, some of them unintended. However, it is to be expected that there will be also non-regulatory reactions to the introduction of personalized prices through inherent market dynamics, but also by consumers, which we will focus on now. As we've seen in the past with the rise of ad blockers and price comparison websites, amongst others, consumers are not helpless. They either fight back themselves or make use of intermediaries to better their positions. With personalized prices, we could expect different techniques implemented or used by consumers in order to prevent or circumvent price discrimination. Although traditional price comparison websites would not work anymore, as I told you above, new intermediaries would rise with adjusted price gathering techniques. One could, for example, think about plugins that would log or report each individualized price and then build a new market price. But also on an individual level, we could we could expect anonymization techniques to avoid price personalization in the first place, or buyers could collaborate in co-shopping, masking their individual profiles. Nevertheless, as promising as such conduct sound, we have to see their downside too. From an economic perspective, it increases transaction costs, which leads to a less efficient market and higher market prices for everyone. And from a justice perspective, we have to notice that the consumers that have the time and knowledge to make use of such techniques are in general not the people that need consumer protection the most. On the contrary, counting on such techniques is prone to disadvantage the already vulnerable consumers even more. Therefore, I think it is necessary to protect the consumers and avoid harmful online behavior and other negative consequences through regulation. I cannot talk about Israeli laws, but if we have a look at the German situation, we see that present regulation is not sufficient. There are some boundaries as to what you can do with your prices, but since the German discount law has been overturned in 2001, as a business owner you are in general free to set your prices at your own will. This makes sense as our whole economic and private legal system builds up on the principle of private autonomy and other freedoms to act. Only where necessary, from a legal economic point of view, where market failure exists, these principles are limited in order to... Oh, okay. I thought I had like 5. Well, I hurry then. Only where necessary, these principles are limited in order to protect the market or market actors. Such exceptions are implemented either based on the actor's behavior, for example for exploitation, unfair practices, or deceptive advertising, or for whole market segments. I will not go through the whole list I looked into so far, but I can tell you that there's no specific regulation in Germany as well that is sufficient to go along with personalized pricing. However, specific regulation is about to be implemented at the European level. As part of the Consumer Protection Modernization Directive, a new Article 6, Paragraph 1 EA will amend the Consumer Rights Directive and mandate an information duty where personalized prices on the basis of automated decision making are implemented. This means that in distance and off-premise contracts, personalized prices will have to be marked as such in the European Union. I think this new transparency duty is a necessary and welcome step in order to mitigate information asymmetry and help consumers in rendering self-determined decisions, especially as I think there is no risk of an information overload as we know it from the fields, for example, of privacy statements or standard terms and contracts. So going on from here, let me quickly dip into further regulation questions. The main question will be how can we neutralize risks without blocking opportunities? While I'm pretty confident that an outright ban of price discrimination is not necessary and not a viable option, there are some sectors that are especially vulnerable and sensitive and could require at least a sectoral partial ban. I'm thinking here especially about, for example, sectors of basic need as medication, groceries, housing, or transport. Besides, there has been the proposal of supporting a transparency obligation with further mechanisms. First, one could consider an obligation to additionally require displaying a reference or average price, and this would even further mitigate the information asymmetry and help the consumer to properly evaluate the offer. Next, as another step, one could implement an obligatory option to switch or choose. This would give the consumer the option to revert to a standardized price in each individual case. Unless both options are implemented together, however, the consumer would face a tough decision here as she could not be sure whether her personalized price is higher or lower than the standard price. An additional option in this case is to design such a right to choose as a one-way ticket or with the option to go back and forth between standard and personalized prices. I'm out of time, so just a quick recap for the people who were in the afternoon low and couldn't absorb everything. My definition is personalized prices are automatically set individual prices based on the assumed willingness to pay. They are not widely implemented yet, but given the right circumstances might be broadly adopted soon. And although they have positive effects, negative consequences are to be expected and have to be faced with proper regulation. Thank you very much for your attention. I'm happy to input later on, and you can also contact me after if you're interested in further details. Thank you.
Okay, thank you. Thank you very much. It's a pleasure to be here, and I will try to be as precise and concise as possible because I know it's a bit late and I'm the only thing that holds you from your dinner. So thank you, Deborah, for the kind introduction. In the time allocated for my presentation, I wish to highlight a different aspect of data regulation, more precisely how regulation of data impact the technology. And I've heard some of your presentation. I think it's very interesting because we all discuss about regulation, data regulation, and I think that in some parts when you talk about the positive impact of regulation, we tend to forget that there is a price on regulation. We have to ask ourselves if the price is right, if it's justified. So I will start with the assumption, yes, so it's all about data. And I presume that most of you heard the concept artificial intelligence, that probably heard it today. And AI is everywhere. In recent years, the legal community is more and more interested in to learn about the relations between AI and different areas of law. And my research investigate the relations between intellectual property and computer-generated programs, or the ownership of AI creations. So what AI has got to do with data and data regulation? Well, everything, basically. Data is the building blocks of AI-related technology development. And I should take a small step back to explain something that is very important for understanding my next slides. So what is AI? I mean, contrary to common belief, AI does not exist. So I've heard many people talk about AI. AI does not exist. What we basically have today is something that's more related to what we call machine learning or deep learning. There is a big difference between the two, but mostly most of these AI-related inventions are deep learning, and deep learning is basically only data, because for a program a deep learning system, you need masses of data. I don't know how many of you know how much data you need to develop the very simple deep learning algorithm. If you can try, like, how much data do you think that I need to program a computer to differentiate between a cat and a dog? What do you think? What? Just throw it. What? Oh, if you read my aspect, you know. It's around between 2 to 2.5 million pictures. So some of these pictures probably protected, regulated either by privacy or by copyright or by other elements. But basically, we need a lot of data. And if you have some problem with this data, it means that the machine, this deep learning machine, would be in many ways negligent or unable to produce the result that we aspire to. So. So its algorithms do not require specific instruction and can learn and evolve by acquiring and analyzing data. That's the other point. Facebook, Amazon, Google, Microsoft, and other companies are gathering data, indexing pictures, videos, and messages to improve their search, translation, and commercial algorithm, which is something that is very important for me to highlight, because what it means is basically that there are companies, there are firms and companies that have access to very good data, what I call high quality data, while other companies don't have this access, which means that if these companies want to develop an AI, it will probably be very difficult for them to develop. And that aspect, I think, what might happen, and maybe even happening today, is that only the big companies are, they're the big companies that are basically the strong company that hold the market. And it's very difficult to small companies or medium companies to enter this market, which cause different problems. I've heard, Jacob, your presentation, and actually one take on that is the competition aspect, which is something that is, maybe I'll ask you about that later, but that's one trigger that I think that is relevant to understand here. So I prepare something for you because I realize that it's probably late and you're probably tired, and it's very difficult for me to explain the concept of bias, which is very important for understanding the importance of data and the importance or the problem that we have with data regulation. So Google made something better for you. So I'll try to, if it works. If it's not, I'll just skip that. But yeah, that's always the.
You won't give up so soon.
It's very neat
Yeah,
and
try here.
here.
Try to put it on here and then click it. That didn't work.
No, I think it's like. All right, we'll
Right now.
Yeah.
Sometimes
Yeah, the I think it will.
For a second. We'll just do in the display settings, as a duplicate. אז נראה את אותו דבר.
Wow.
ואז...
That's amazing. I'm supposed to be a tech guy.
Yeah, another error.
I don't know. It's probably, you can't probably watch that, but it worked this morning. It worked this morning, so I don't know. All right. Yeah. Well, how can I get back to the slides?
Right.
No, just
Oh.
show the presentation and go
Cool.
from there.
All right. We'll just skip that.
תמשיך.
Okay. All right. So I'll just. I'm sorry for this inconvenience. I just explained this, and the clip would basically explain how bias happens. So the concept of bias basically means that when you teach a deep learning system or a machine learning system, what happens? The process is that the machine, and I think I have this here, the machine is gathering information, it's gathering data, and the data is being processed as in the machine, and that would mean that after the product will probably present either the process itself, what we want to do, or something else. And the problem with bias is that when we uploaded data that has some certain characteristics and other elements which has some sort of bias towards certain people or certain criteria or something like that, that means that the output that this machine will be resulting in will will possess this bias too. And this is why I think that one of the leading argument in that area is that when we aspire to develop a good machine learning or deep learning system, we have to be more, we have to understand this problem and to be able to provide this machine with data that will have some sort of element that will be clear of bias or any other element. So developing a good AI algorithm requires access to good data. Good data can be characterized as recent, relevant, with high resolutions and details. There are several ways in which access to good data might be restricted. I will address only three aspects: copyright, privacy, and contract. So in copyright, very briefly, in copyright, AI can infringe copyright by making digital copies of copyrighted works and saving them on either the hard drive or the cloud. Where the AI's input, the data infringe copyright, the output may infringe too. Obviously, not all data is copyrightable. Facts and raw data obviously is not. But there are other elements that are copyrightable, and that's one of the aspects that we have to consider, because I mean, most of you probably knows it, but copyright is basically some sort of regulation. It's a type of regulation. It prohibits people to use something that someone else created, and if you want to use it, you either have to pay royalties or to get the approval of the author. So obviously, that's some sort of the way that the law protects ownership and other elements from other people to use. The problem is that, as I mentioned before, that the current legal regime renders the AI market accessible only to the dominant developers. So I think that's one of the issues that we have today. Only the dominant developers have access to what we call good data, because when you sign up to Facebook, Twitter, or other accounts, you basically give them permission to use your data, and this is the best data anyone can find. Its data is very good, it's high quality. You can characterize and you can define certain things from this data that can be very useful for a machine learning process and product. So that's very high quality data. However, if I'm an AI small company that I don't have access to this data, the only way for me to gather this information is either by using what we call open source places. For example, we can scan Wikipedia and we can use open source books from before 1924. And the problem with using this data is that this data will contain bias to certain people, to certain aspects. For example, think about AI companies that could use the adventures of Huckleberry Finn, or a Busy Smith song, "Baby, won't you please come home?" If you use data with these specific terms and terminology, what the process is going to be? The process is going to be that the computer, the AI, will develop a book, maybe a book or any other a product that will have some special characteristics. For example, you can expect that the lead player or the important part in the book will be a man, a white man, and if we'll have some types of songs, the songs will have some bias to other population, because if you remember before 1924, when you used the word gay, it meant something else that it meant today. So that's the problem that we have with these sources of data. A different type of a different barrier is reflected by the common the common internet contracts. What we call term of use. This is one thing that you probably know. Term of use. Every website, internet that you're using today, you can click and you see the term of use. I don't know how many of you know, but in these terms of use, there are restrictions for for data, like for using of this data, or to gather information from the website. So it means that if I'm a company and I'm using crawls or other elements to search the web for information, I basically infringe contracts all the time. And if I don't get approval from the companies to use this information, I can't use that. Again, it's another restriction. And the third part, which is something that I think most of you we already discussed here, and I think it's probably quite obvious, and there are good reasons for that regulation, is privacy. Well, I argue that privacy on the conceptual level is good and important. Everyone wants to keep their private information safe. Yes, yet I agree that privacy is good, but we should not avoid the price of privacy. And this is one thing that I want to highlight here, that any type of regulation has some sort of price. Privacy is good, but we have to consider the prices that we have with privacy. The most notorious privacy regulation, as you know, is the GDPR, or the General Data Protection Regulation. I won't get into too much details about GDPR. I assume that most of you heard this word. I just want to highlight one aspect, the requirement to explain the uses of data. I don't know if you heard about that. It's one of the requirements related to AI technology, or what we call machine learning technology, is the requirement by the GDPR to explain the process. And the challenge is that it's very difficult to provide an explanation about the process of AI-based systems or deep learning algorithm. So I think that if you try to look into the system, the problem that you have with this system, that you put the input into the system, but in many cases you can't really understand how the system get to that conclusion. And you saw that with many examples. I don't know if you heard about the Go player. If you heard about this, there was a Go. It's a very common Chinese game, and a few years ago they tried to teach a machine to play this game, and after a certain time, this machine managed to beat this player in the Go. And the thing is, what was very odd is no one really managed to explain how the machine did that. Like, she did something that was considered to be really odd. So this is one of the problems that we have with this type of machines. We can't really explain. If we can't explain, basically every use of data within the GDPR construct mean that we can't really explain the process, which is something that might be considered an infringement. So let's talk about the solutions, okay? So I think that one of the, we established that, so I'll just move to the next slide. So one solution is into this problem is what we call tax and data exemption legislation. This is something that was considered recently in Canada, and we'll talk about that briefly in a sec. Several jurisdictions introduced TDM exception legislation. TDM is basically a text and data exemption. It allows companies to use text and data in certain areas and certain jurisdictions for these purposes, for developing AI and the machine learning system. In 2014, the UK amended the CDPI, the copyright law, to include a non-commercial research exemptions. There is a difference, of course, between commercial and non-commercial exemptions, which is something that we should understand as well. In 2016, the EU Commission introduced a new directive, Copyright in Digital Single Market, which included an exemption for TDM. Both Germany and France include in their copyright charter non-commercial TDM exceptions for scientific or research purposes, which is something very interesting, because in other countries you don't distinguish between commercial and non-commercial. In Canada, for example, we suggested to have a sort of a broader exception for data mining, which would not differentiate between commercial and non-commercial, because one element that we consider there is a lot of, or many of these so-called non-commercial eventually turn up to be commercial, or commercial aspects of research, and you don't want to limit the possibility or the potential of collaboration between companies and firm and industry leaders. So that was very important for Canadians from that perspective, to bring the industry in Canada. One other element, one different exception, so you might be aware of, is what we call fair dealing or fair use. You heard about that. That's a very old, copyright doctrine that deals with exception to copyrighted information. It's a permanent legal mechanism. Admittedly, there is a problem with for the interpretation of this fair use or fair dealing across jurisdiction. There is nothing really, common that we can say that is worldwide accepted, but there are some consensus around the basic terminology. But I basically think that fair use or fair dealing is something that is good, but it's not sufficient. So my proposal, and this is what we try to explain to the Canadian officials and the federal committee that discussed this potential, is basically to say, listen, I think that we have a problem, and as part of, I think, every country innovation policy, if you want to get more and more companies to get into the country and to research this area, to research these technologies here in Canada or in other countries, what you have to do is to be willing to take the risk and allow these companies to to use information, to use data. Obviously, it's only cover a very limited scope of exception, because you are not going to give people exception to use privacy-regulated data. So you don't want to give them that, because you want to make sure that people won't use private data. But from a ownership or copyright angle, and the understanding is that then when you take a photo of a picture and you use this picture for the purpose that this picture intended for, that you put it on a show or in your room or in your classroom or something, that's something that should be prohibited. But when you use the picture for different purposes, and when you use the picture for as data, which is something else, to produce something that is different, then it might make sense to be able to use this picture for those purposes. And the problem that we have today, that in a lot of in many other resources or data, what you have with this information is that a lot of, or many companies are facing litigation, and it caused some sort of a chilling effect in the industry, and it's something that I think it's something I think that it's not useful. So that's basically what I propose, to start to implement a text and data mining exemption as a separate part of the copyright or other laws. So, thank you.
Any questions from the audience for our speakers? And you can raise your hand and sort of turn around and look at each other. I don't think we need to do a panel. Yes, sir.
Question for Jacob Metzger. My day job is the Israeli Competition Authority. So we actually partly look at this price discrimination, and personal price discrimination is a good thing when you talk to competition experts. And first I would say I don't agree. I'm not sure we're really there calling automated pricing personalized pricing, because it doesn't know who I am. It just knows that I've used an iPhone that I shopped about 15 times before, and I might have a problem of a habit. And so this, which is not personalized, it may be illegal discriminatory pricing, because it may be based maybe on geographical location or something which may be even gender or race related, and therefore that would be the problem. I'm not. My question for you therefore will be whether it is actually what economists call personalized pricing. What's happening today, I think, is categorical pricing, and maybe we're not really there. So that's the question for you.
I'm totally with you on that. I don't think we're there yet. I think we'll never reach the point what economists call price discrimination of first degree after Cécile Pichot. He says that personalized pricing is only the pricing that is really based on the willingness to pay of an individual, and I don't think we will ever reach that point where we know exactly of every person how much he or she is willing to pay. But Wagner and Eidmüller, for example, call it almost perfect price discrimination, and that is a status that might be reached soon. I totally agree with you, we're not there yet. At the moment, it's very basic assumptions on readily available data, as for example, whether I've come from a price comparison website before, or which phone I use. So I think there's still some technological development to be expected. But I think we might get into a world where we have this near perfect price discrimination, and that is a whole other level that gives totally different questions than we have right now. So I think it will be a bigger problem in the future.
Great.
Can I add something on that?
Sure.
I don't think that the problem is price discrimination in economic terms. I think that the problem might eventually be that if I observe your behavior, then I can observe how much you have been accepted paying for a certain product. So you know how much you are not be willing to pay, how much you are available to pay, which is a different kind of information. So how much I can extract from you, that's a different thing.
That's totally different.
That's totally different. I think that is the problem.
And also, it's the my comment in general is, I know this panel is about private law, but then how constitutional law or basic rights are involved in the sense of each one of your lectures, which were really interesting. But let's say for the pricing mechanism, so it's not just your I know the amount of wealth that you have, but also the amount of necessity that you have, right? If you're sick or your mom is sick, or so. And if I take on the data or privacy, so there are other questions of like the distribution of wealth, or who profits from my data, just the big techs or no. And so I wonder when we, maybe it's, I don't know, maybe it's too general question for, but just the economic perspective on these questions, I feel is a bit too narrow when I look at in what society I want to live in.
If I may quickly answer to that.
Thank you very much for that question, because that's exactly the point, that I'm not really looking into the question of what data they will have about me and how they can collect this data. So the data processing aspects are not that interesting for me, but rather the results. So what happens when once they use that data for personalized pricing, will there be problems with the economical aspect? But what I left out right now is also a question of distributional justice. So who takes advantage from that? Because if you look from it from an economic perspective only, the basic result at the moment is that it's kind of neutral. Some people gain from it, some people lose from it, but from a welfaristic perspective, it's kind of neutral. So what I want to do in my thesis is go on from that point and exactly look into the question. So what else is there? Is it fair to be, like, to speak very broad, but yeah, I'm not there yet.
Thank you. Anybody else? Yes, sir.
I want to ask Yaakov. When in the last vacation, I was looking for a ticket to a show for my kid. And I was going to 5 different sites. And in each and every site, I saw the same ticket for the same show, for the same chair, in another price. And I know that when I came to the show, each one has another price. But because I know that this is not because of me and because of the information that they have about me, but because of the site, somehow it didn't, it wasn't a problem for me. The question is, well, is it really there? Is it really only the question of privacy that bother us? And the second question is, should it bother us? In the mathematical example that you gave us, in the example of the picture, 2 out of the 4 people got the picture only because we have somebody had an information about them and could sell them the picture in a lower price. Maybe it's better for them.
Thank you very much. First, for your first example, I think when you mentioned the example where different people pay different prices for the same product, I mean, that's a basic idea of competition. Some operators will have it cheaper but with less service. Other operators will have it more expensive but with a better service, customer service. They send the ticket to your home maybe, I don't know. So I think there you still have a different product, but even if it would be the identical product, it feels fairer for the user because it's my own choice to which of those companies I go. With personalized prices, I have the fear that it will not be really my choice anymore because I can't really compare between the companies. So I have a set price and it's more like a take it or leave it situation. There might develop other price comparison strategies over again, but at the initial there might be it might be a little bit harder. Also, when you ask what really bothers us, there are tons of studies about this, really interesting, and there are different aspects that have been looked into far. So, for example, personalized prices bother people with less economical background more. So the less you know about the market dynamics and economics, the more it bothers you. Which maybe is why it bothered me at the beginning more than it bothers now. But also depending on whether you can change the behavior or like whether you can change the factor that is priced in. So if it's based on your gender or on some objective personality aspects about yourself, people are way more skeptical than if it's, for example, based on the phone they use or the web page they visited, because they have a feeling they can still control it.
I would just, if there are any more questions, sort of, we have another, I think we have time for one more, but I think there's some really interesting connections between the two of you, actually, because as you're talking just now, I'm thinking, well, what are the implications of bias for the kind of information that influences personalized pricing?
Yes.
And that sounds like, I think that's an interesting conversation.
I mean, this is a great question because I don't know if you said you're from the competition, you have some competition background. So in 2017, you probably know that there is a report published by Ariel Mizrahi from Oxford dealing with some sort of aspects of that problem from a different angle. So what they do, they looked into I think it was casinos in the U.S. and the casinos in the U.S. use promotion. They took the people they are targeting, like target specific people that travel to this casino, and they managed to find a way of developing an algorithm that will be able to target this type of people that they think that they're more inclined to pay more or to gamble more. And they gave them promotion instead of give it to other people. So it's a sort of a personalized way, but in a way it's caused some other difficulties, some different difficulties in related competition law. So that's issue. I think that's there is a very interesting relation between what you said and what happened today relates to competition and to other aspects as bias, because it's all, I think, in many ways it's sort of related to each other, and what you learn probably be affected to the impacts the other aspects of other areas in copyright and other types of regulations as well.
From a competition point of view, I don't think that there is much to do. I mean, you can't really intervene for competition.
This is one of.
No, I don't think you can. I am on board of ASCOL. I think you might know the association, and we have a lot of seminars over this problem of personalized prices, and there is no way you can intervene. While pure regulation you were mentioning before, I mean, now there is this regulation transparency and fairness, but which has just been very recently adopted 2 weeks ago.
Yeah.
Okay, now we have transparency, so consumers will know that there is a personalized pricing running over platform. Then what?
So the what, we're going to take the what. I apologize, and we're going to move it into our dinner context, I think. So I really want to thank our panelists. You're all fantastic.